In civil cases where money is at stake, there is extensive discovery by the parties. In other words, in a civil case, each side will give the other side the name of all the witnesses that know anything about the issue in dispute. The parties will even be able to take depositions. That is, they'll be able to sit down with the witnesses one at a time and ask them questions, and the witnesses will answer the questions. A court reporter will take it down. They'll be able to see any documents that are going to be introduced that have any relevance to the case. They'll inspect maybe the scene of where the incident was, whatever it may be. But basically, by the time the trial starts, everyone will know everything about the facts of the case, and the question will just be presenting those facts and having the jury decide it. Criminal cases where life and liberty at stake, quite different. In many jurisdictions in the country, in many places, it's trial by ambush. The defense really doesn't know who a lot of the witnesses are until they take the witness stand and testify against them. The criminal rules generally prescribe that, and again, this is generalizing over 50 states and the federal government, so there are differences in each place, but generally, the prosecution must give the defense lawyer any statements made by his or her client, any documents or tangible evidence that might be in the possession of the prosecution that might be used, that can be seen, any mental or physical examinations which are taking place, the defendant's prior record, in other words, the rap sheet, and a summary of any testimony of expert witnesses. But that's the minimal. That's about all that some jurisdictions provide. So, as I said, often it may not know if a witness, what a witness is going to say until that person takes the witness stand, or even who the witnesses are, or what the background of the witnesses are. Well, the Supreme Court has held that at least in some instances, particularly when there's evidence that tends to show the defendant did not do it, or at least can be arguably or used in an argument for innocence, that the prosecution does have some responsibility to disclose evidence. The Supreme Court held in 1963 that the prosecution is required to disclose any evidence that's favorable to the accused. This was in a case called Brady versus Maryland, and that case is often just used as a term now for the disclosure of evidence, Brady evidence, as people will call it. But we're talking about exculpatory evidence. Not long after Brady was decided, the court decided another case called Miller versus Pate. In that case, the prosecution had argued throughout the trial that the stains on some undershorts that had been recovered from the defendant were blood, when in fact the prosecutor knew all along that they were paint. And that they were not. So the Supreme Court reversed that case and made clear that in that kind of situation, that evidence has to be disclosed to the defense. The court has also said that a prosecution cannot knowingly present false testimony during the prosecution's case. In a case called Napoo versus Illinois, decided in 1959, the prosecution witness, the witness testifying for the prosecution, said he got nothing in exchange for his testimony, no reward, no incentives whatsoever. In fact, the prosecutor had promised to seek a reduction in his sentence. So the Supreme Court said you can't do that. If you make promises, if the prosecution makes promises to a witness, then the prosecution has to disclose that to the defense, and that can be used to argue the credibility of that witness. In Giglio versus United States, decided in 1972, one prosecutor had promised a witness that he would not be prosecuted if he testified, but then there was another prosecutor who didn't know anything about that particular bargain that had been reached, and when the witness testified, he said there had been no promises made to him. Again, the Supreme Court said the entire prosecution office has to be responsible for knowledge of what deals have been made, and reverse that case as well. These are the easy cases. These are not cases that are going to be hard to decide, but we will see that this becomes much more complicated as the cases become more involved, as there are more factual disputes in the case, as there's a question of whether the evidence just tends to raise some question about the strength of the prosecution's case, or whether it's actually exculpatory. And of course, the other part of this that I should mention is the question of whether or not the defense ever becomes aware of it. Undoubtedly, there are many cases where there's evidence, such as what I'm going to talk about in the Graves case and John Thompson's case, which never comes to light, and therefore there's no issue. But where the evidence is discovered, serendipitously, someone calls the defense lawyer and tells them about evidence. Often there's Freedom of Information Act or Open Records Act litigation that produces evidence that the defense did not know at the time of trial. And if that's the case, then there may be litigation about whether or not a case has to be set aside because the failure to disclose exculpatory evidence. The Supreme Court, in later cases, though, cut back quite a bit on what's required in terms of disclosure. First of all, the court said there was no violation, at least in the case of Augers versus United States. This was a failure to disclose the criminal record of a witness. One of the things the court looked at in deciding that case was the fact that there had never been a request made by the defense for that record. And the court said this did not violate Brady versus Maryland. This was not a violation of due process, which is the part of the Constitution, the Due Process Clause of the 14th Amendment, that states are required to provide this information, or the Fifth Amendment in federal cases. The court said the prosecutor may not have known the evidence was exculpatory or may not have known that the defendant wanted it. Also, there's no violation if the evidence is not material. That was what the court said in a case called United States versus Bagley. There, even though the defense requested that any deals and promises that had been made and the prosecution had not disclosed witnesses had been paid money for the testimony they gave, the court refused to reverse the case and said it was not material, that evidence is material only if there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. This is really a harmless error standard. Basically, the court is saying this is evidence that even if it had been disclosed to the defense, it would not have had an impact on the outcome. Of course, the argument is that appellate judges who didn't see the witnesses, who didn't sit in the jury box, who don't know how the jury assessed the case, may not be able to really know whether or not, had this evidence been presented to the jury, it would have affected the outcome or not. Anthony Graves' case provides an example of how close these questions can be sometimes. The key witness against Anthony Graves, who was sentenced to death in Texas, was a fellow named Robert Earl Carter. And he had told the prosecutors during some private meetings with them two things that were important. One, that Graves had nothing to do with the crime. And second, that Carter's wife, Cookie was her name, was involved in the crime with him. Of course, at trial, he testified that Graves participated in the crime and didn't make any mention of Cookie participating in the trial. The court found that the prosecutor did not disclose this information even though Graves' counsel had requested it. In fact, the prosecutor had deliberately misled the defense counsel with regard to these statements that Carter had made. And in addition to that, the prosecutor called a Texas Ranger, Kaufman, who testified that Carter had never said anything different. Now, obviously, the prosecutor knew that this statement that Ranger Kaufman made was not true. He knew that it was false. And as a result, the United States Court of Appeals vacated Graves' conviction. His case was sent back, and it's interesting to look at the history of the case before it made its way to the United States Court of Appeals for the Fifth Circuit. Graves had first tried to raise this in the Texas Court of Criminal Appeals, but unfortunately had a very bad lawyer with very little experience who didn't raise the issue, and then when they tried to raise it a second time, the court held that it was barred, that it was procedurally barred because it hadn't been raised the first time. Then when he gets to federal court, the magistrate judge who first examines the case and then the district judge who examined the case conclude that there was not a substantial probability that the outcome would have been different had the case gone, had the evidence been disclosed. The United States Court of Appeals for the Fifth Circuit says, first of all, that the provisions of the Anti-Terrorism and Effective Death Penalty Act do not apply in this case. This is, as we've talked about in other segments, greatly restricts the power of the federal court to issue a writ of habeas corpus in a case like this. The court also found there was cause for the procedural default, that where some issue was not presented, was there a reason for that? And the court said there was in this case because the state did not disclose the evidence until after the case had already gone through, or at least disclosed some of the evidence, until the case had already gone through the entire state appellate process and was actually in federal court when the evidence came to light. So Graves can hardly be faulted for not having raised the issue in state court when he didn't even know what the prosecution knew at the time. The case goes back for a retrial, but the new prosecutor brings in a very experienced Harris County, that's Houston, assistant district attorney who had tried Kelly Siegler. She'd sent 19 men to death row in her career as a prosecutor in Houston. She called the prosecution of Anthony Graves at his first trial a nightmare and a travesty. She said it's a prosecutor's duty never to fabricate evidence or to manipulate witnesses or take advantage of victims. And she said all of these things happened in this case. Here's a case in which a man was prosecuted, sentenced to death, denied any relief in the Texas courts, partly because he had a very bad lawyer for his post-conviction review of the case, but then wins the case in the United States Court of Appeals, and when it goes back and an independent prosecutor is brought in to assess it, finds that there's this kind of prosecutorial misconduct that happened in the case. Anthony Graves has been free ever since. He talks to people around the country about his experience. What happens, you can learn more about Anthony Graves by going to his website, anthonybelieves.com. One other case that illustrates both the question of disclosure as well as accountability is the case of a man in Louisiana, John Thompson. John Thompson was accused of separate crimes, an armed robbery that happened one time and a murder. These crimes are separated by about 2 weeks, and they happened in New Orleans in 1985. In the armed robbery case, the police had taken a swatch of fabric that was stained with blood of the perpetrator. These were some kids who got robbed, and in the process of it, there was a scuffle and there was blood on the pants, and the police took a sample of that. This is, of course, the kind of critical evidence that law enforcement uses to solve crimes. They sent it to the crime laboratory, and it came back that it was blood type B. There's no mention of the results of the blood test at trial. In fact, 2 days before trial, one of the prosecutors gave the crime laboratory report to another prosecutor. Now, that prosecutor later denied it. This is the report that said what the blood type was. Before trial, the prosecutors checked all of the evidence out of the property room of the police department except for that swatch of fabric that had the blood on it. Thompson goes to trial. This is in the armed robbery case. He's convicted. That's then used against him at his capital case so that he doesn't take the witness stand. He's convicted. He's sentenced to death and spends 18 years in custody, 14 of those years on death row. One of the prosecutors, Jerry Deegan, learning that he had cancer and that he had little time to live, admitted in 1994 to another prosecutor that he had suppressed the blood evidence in John Thompson's case. But that other prosecutor never disclosed that to the defense or, for that matter, to anyone else. John Thompson was scheduled to die on May the 20th, 1999, and he almost did. What happened was that an investigator started looking, leaving no stone unturned, looking one last time, and went to the crime laboratory and discovered the blood report that had been there all along that said the perpetrator had blood type B. Couldn't have been John Thompson. John Thompson's blood type was O. And so once you have the blood report, Thompson could not have committed the crime. And in fact, the armed robbery charges against John Thompson are dismissed. The Louisiana Supreme Court then reversed the murder conviction, saying that because it was tainted by this earlier conviction, Thompson was entitled to a new trial. And at the new trial, John Thompson testified. A number of other people that knew about this incident testified. As it turned out, and in all probability, the person who had accused Thompson of the crime was probably the person who committed it. He came closer to fitting the description than Thompson did. At any rate, it took the jury just about a half an hour to acquit John Thompson. So after 18 years in the custody of the state of Louisiana, 14 on death row, John Thompson walks out a free man after he's acquitted. But he does more than that. Thompson sued the district attorney, Harry Connick Sr., and others, saying that misconduct by the prosecutor's office, basically the failure to disclose this blood report, had cost him 18 years of his life and had nearly resulted in his execution. Prosecutors have complete immunity for what they do as prosecutors, so he couldn't directly sue the prosecutors who tried his case or Harry Connick Sr., the main prosecutor, but he did sue Harry Connick and other people on a theory that there were so many of these violations, so many times when prosecutors in New Orleans had failed to turn over evidence. There had been 4 cases reversed before John Thompson's for the same reason, that he had failed to train his lawyers so that they would be sure to find and turn this evidence over as they're required to do by the Constitution of the United States. A jury in New Orleans awarded John Thompson $14 million plus $1 million in attorney's fees. But that was soon to be taken away from him by the Supreme Court of the United States in Connick versus Thompson. Connick won at trial. The Court of Appeals split evenly on the case, but the Supreme Court granted review and said that there was not enough reason for Connick to require that his prosecutors be trained. This is not like, the court said, sending police officers out with weapons without training them on the constitutional limitations on the use of deadly force, which police departments do. The Supreme Court said that there was no reason to think that the deputy district attorneys would need special training. After all, they had been to law school. They are responsible as lawyers to continue their education after law school, and they learn on the job from other prosecutors. Of course, that was one of the problems that Thompson was raising, that perhaps learning from other prosecutors in the Orleans Parish District Attorney's Office was not really teaching the right lessons. That is, that this kind of evidence has to be disclosed as opposed to suppressed. Justice Ginsburg dissented. She was joined by Justices Breyer, Sotomayor, and Kagan. So this was a very close case. John Thompson lost the $15 million by a 5-4 vote of the Supreme Court. Justice Ginsburg, in her dissent, said from top down, the prosecutors did not understand their obligations. They hid all kinds of exculpatory evidence, not just the blood test, but all kinds of evidence from Thompson, which he had requested over 2 decades, and it almost resulted in his execution. In another segment, we'll talk to John Thompson about his experiences, the trials he had, the time he spent on death row, and his effort to hold the prosecutors accountable by filing this civil suit, winning it initially, but then losing it at the Supreme Court.